Thank you very much. I want to start by welcoming all of you here in the room, as well as those following us online. And of course, I would like to thank to our guests and to our moderator to be with us today to discuss this important topic for millions of families and children in the European Union. Currently, a family might be subject to different laws in different member states to determine who is the parent of a child. This means that a child may lose their parents, legally speaking, of course, when they enter in another member state. This puts them at a significant risk, and they do not have guaranteed access to rights such as those relate with succession, maintenance, or education, to give you some examples. We are talking about children that already exist, and we cannot discriminate a child because of the way they were born, the type of family they were born into. The current legal landscape particularly affects rainbow families, and especially those in which there are no biological link between the parents and the child. So with this proposal, we are trying, that comes from the Commission, as a very simple aim. It assures that if a member state establishes a child-parent relation, all other member states will have to recognize it. In other words, if you are a parent in one member state, you are a parent in all member states. Having said this, we cannot just create a right to recognition. We need to make sure it's as easy as possible for families to access it. This is why in my draft report, I have suggested a number of ways to simplify the proposal of the Commission, making sure that as much as possible the process can happen with use of digital tools. Digital also serves to improve our rights, and that individuals are not asked for the same document more than once. As you know, the biggest difficulty of this proposal is that because of the legal basis of the treaty, it will require unanimity of the Council. So the Parliament also only has a limited role in this process, as it will only be consulted by the Council rather than being a co-legislator, as in other situations. Therefore, as the rapporteur for this proposal in the European Parliament, my goal is to find a broad majority for it in order to put public and political pressure on the Council. I hope this workshop and discussion you are going to have here today serves to clarify any questions that you, the audience, might have related to these proposals. And of course, I look forward to hear your ideas on how we can further improve it. Thank you very much. And I give the floor.
Muito obrigado. Muito obrigado, Maria. Thank you very much. Just to, I guess, my name is Chris Burns, and I'll be moderating this. I want to keep in mind some of these tech tips or these housekeeping tips. I guess you can see that the interpretations, channel 1 is German, channel 2 English, channel 3 Italian, channel 4, channel 3 is French, channel 4 is Italian, and channel 8 is Espanol. So to keep that in mind. And also, very important is we are connected via YouTube, and you can go into the chat and participate there as well. and to send in questions as well through the chat, which we will be looking at during this discussion, because we want to get as many of you involved as possible. This is as Maria said, this is a workshop. And it's extremely important because this is still kind of like clay. We have a draft report, but we want to see how maybe it can be modified or changed, or how it could be, in trying to get that unanimous support through the council. Also keep in mind, hashtag parenthood for anybody who would like to tweet, and please do. And @theprogressives is the handle for that. So the format here is, as you can perhaps see after Maria's opening remarks, we have two panels. The first one is actually really drilling down and looking at the proposal. And then the second one is critical assessment, and then closing remarks with Maria. So let's get started with we have, with Maria. After Maria, we have a video message, correct?
Yes.
Yeah. So let's go to that video message from Ivan Garcia del Blanco, S&D JURI coordinator, where he talks about this as being a step forward. Let's listen up.
Hello everyone, and welcome to the S&D JURI workshop on cross-border family situations and the recognition of parenthood. Even though I cannot be there with you today, I'm very glad that we are organizing this workshop within our group. The proposal of the European Commission on the recognition of the parentage between member states is a step forward in protecting children who could be deprived from certain fundamental rights and rights derived from parenthood in cross-border situations. It will help families by providing them with legal certainty and avoiding burdensome administrative and judicial proceedings. In addition, this proposal is the perfect opportunity to shield not only rainbow families, but also those that do not fit in the mainstream family model that the conservatives want to impose. The far right say they want to defend the family, but only the so-called traditional one. They are determined to undermine LGBTQ+ rights. Proof of this are the latest inhuman attacks against the community in Italy by Meloni's government, or the recent removal of rainbow flags in some cities in Spain, promoted by Vox together with the EPP. This is why this proposal is very timely and great opportunity to shield non-traditional and rainbow families' rights in the European Union. We, socialists, have always stood for the LGBTIQAI+ community, and we will continue to protect them from the anti-democratic backlashes that are now proliferating in Europe. With this proposal, we want to ensure rights for everyone, regardless of the type of the family they come from, as long as the rights of all are respected. We need to guarantee that everyone is free to safely shape the type of family they want to. Inclusion is at the Europe's core, and therefore there should be no place for discrimination in the European project. Thank you, and I hope you have an interesting and fruitful workshop here today.
No place for discrimination in the EU project. That is very important. That's the point of this, right? I can kind of relate because I have family members who have had children in, shall we say, non-traditional ways. And what happens with those estimated 2 million kids across the EU whose legal status can be in limbo? What do we do about that? Well, this is supposed to address that. Maria Vilar Badia, this is the first beginning of the first panel here on parenthood, the parenthood proposal, its aims and implications. Maria Vilar, European Commission, DG Just, you're a legislative officer on civil law with cross-border implications. Maria, I guess you have a presentation to sort of describe what this is about.
Thank you very much, and thank you in particular to the rapporteur for the proposal, Ms. Maria Manuela Leitão Marquez, and to the S&D group for allowing the Commission to present the proposal and debate it with all of you. So I understand I will, next slide, please. Yeah, let me just briefly give you a bit of the background to this proposal. You know, as members of the, well, as people working here in the Parliament, that there have been several times petitions here, and the Commission has received complaints, and we know there's been national cases in which citizens have brought to the attention of the institutions that they have difficulties in having the parenthood of their children recognized in cross-border situations, whether crossing borders, whether moving to another member state, or when they have issues of inheritance or maintenance across borders. What are the causes for these difficulties in having parenthood recognized? Well, there's reasons at 3 levels. The first one is that, as has already been mentioned by the rapporteur, that national laws of the member states have different rules at the time of establishing parenthood and at the time also of defining a family. At union law level, we have already under the context of free movement, legislation and case law requiring member states to recognize the parenthood of children in cross-border situations for the purposes of rights under union law. And which are those rights under union law? Typically and mainly the rights under free movement. So basically the right to enter another member state, the right to move and reside in another member state, the right to obtain documentation for your child. But this right, as it is derived from free movement, it only applies to union nationals or their family members. But in the union, we do not yet have any legislation or case law that requires member states to recognize the parenthood of children for the purposes of rights under national law. And the purposes of national law can be typically, well, those rights that derive from parenthood, such as nationality, inheritance, maintenance, or the legal representation of your child in another member state on matters that can go from medical authorizations to schooling needs for the child. For that, we do not yet have in the Union an obligation on member states to recognize parenthood. And then at international level, for the time being, there is no general convention on the recognition of parenthood. The next speaker, my colleague Laura Martinez Mora, will tell you more about that. Next slide, please. Now, but what are the why are we doing this? Because what are the consequences of these difficulties in the recognition of parenthood? Well, this has a direct adverse impact on children's rights, the right to an identity, the right to have the same parents in different member states, the right to inherit in another member state from either parent, the right to obtain maintenance from either parent in another member state. Then what happens is that families, when they are faced with these difficulties in having the recognition of the parenthood of the children recognized, they start sometimes, if they have the means, the energy, the time, they start court proceedings in an attempt to have the parenthood of the children recognized. But of course, this, as I mentioned, costs money. It takes a lot of energy, and the results actually are totally uncertain, because sometimes, depending on the kind of family, if it is an heterosexual couple, then you may end up having finally the parenthood recognized, but if you're a same-sex family, in some member states, there's no way that you will have it recognized. And then finally, what happens as a result of all of this? Well, what happens is that families, in particular same-sex families, they are deterred from exercising the right to free movement. So they fear that if they move to another member state where the parenthood is not recognized, they will not be able to exercise as parents of their child for all purposes. So then they just decide not to exercise the right to free movement, which, as you know, is a cornerstone of the Union. So to address this, the Commission President Ursula von der Leyen said in 2020 in her State of the Union speech that, as the rapporteur has just recalled, if you are parenting in one member state, you are parenting in another member state. And the Commission took up this political commitment and proposed an adoption, the recognition of parenthood, in December last year, whose primary consideration is obviously the rights of the child and the best interest of the child. Well, some member states interpret best interest of the child differently from others, but the rights of the child are very clearly stated in the UN Convention on the Rights of the Child, the European Convention on Human Rights, and our Charter of Fundamental Rights. So obviously the aim is to facilitate the recognition of parenthood and thereby to protect all these rights of children that I mentioned, to an identity and all others under national law, and also to provide legal certainty as to which law member states should apply to establish parenthood in cross-border situations, which court in which member state would be competent, and also to reduce litigation costs so that families don't need to embark into legal proceedings to have parenthood recognized in another member state. A topic that has been brought to the Commission's attention repeatedly in the Parliament is why has the Commission chosen the legal basis that it has chosen, which is Article 81 of the Treaty, paragraph 3, on family law with cross-border implications, and not, for example, the legal basis based on free movement. And why is that important? Because Article 81(3) requires unanimity in Council and a consultation of the Parliament. That is, that the Parliament is not co-legislator, and in addition, the Council does not adopt by qualified majority, but it does so has to do so by unanimity, whereas a legal basis on free movement would be the normal ordinary legislative procedure and not a special legislative procedure. But why have we had to do it this way? Well, basically because the Court of Justice made clear in a recent case called the Baby Sarah case that you may have heard about, that the right to free movement indeed requires member states to recognize parenthood, but only for the purposes of rights under union law, not for the purposes of rights under national law. So because of that, we could not choose Article 21 on free movement, because the court made very clear that this article would only cover rights under union law, which anyway they are already covered by the case law. But we could not use that to require member states to recognize parenthood for the purposes of rights under national law. And a second reason is that in the treaty, there is this specific provision on measures on family law with cross-border implications, which, as lawyers say, it's a special rule as opposed to the Article 21, which is a more general rule. Next slide, please. So, obviously, like any other instrument, union instrument on family law, this is a gender-neutral text, which means we don't pay attention as to the gender of the parents. And it is a very encompassing text because it covers the recognition of parenthood of all children without any kind of discrimination, regardless of how they were conceived, for example, with assisted reproductive technology, or how they were born, for example, out of surrogacy, or their type of family, whether they have same-sex parents or not, or whether they've been born out of surrogacy in a member state, or they've been adopted domestically in a member state. Also, this applies to all citizens, not just to union nationals, so it applies irrespective of the nationality of the child. But there is one condition, and it is that this obligation to recognize parenthood is only as regards parenthood when it has been established in a member state. When the parenthood has been established in a third country, then it's the member state laws that will continue to apply to the recognition of that parenthood. Now, this instrument, because of its legal basis, it's what we call an instrument of private international law, which lays down rules saying which member state will have the power to adopt court decisions on parenthood, because in cross-border situations, it could be the law of the nationality of the child, or it could be, the court of the member state of the nationality of the child, or it could be the court of the member state of the habitual residence of the mother. So which one should be competent?
And obviously, the issue here would be from in that situation would probably be surrogacy or adoption, right?
No.
No?
No. This we're talking about only here. We're talking about of all possible member states whose courts could decide on the parenthood, which member state would have the competence to do that? Would it be the member state where the child is born? Would it be the member state where the mother has the habitual residence? Would it be the member state of the nationality of the child? Regardless of how the child is born. It's a matter of deciding which member state's courts would be competent. This in the same line. Applicable law means that the proposal has provisions deciding which national law would apply to decide who the parents of a child are. Would it be the law of the country of the nationality of the child, the law of the country where the mother gave birth? Would it be the law of the country where the mother lives or has her nationality? In this cross-border situation, several member states' courts can act and several member states' national laws can apply. So these private international law instruments give criteria and choose which member state will be competent and which national law will apply. Then obviously as a conclusion of harmonizing these rules, there's the judgments and public documents on parenthood will be recognized between member states. Sometimes these documents establish parenthood, which means they decide that the child has this person and this person as parents, and sometimes these documents are typically a birth certificate, which do not establish legally that the child has this person, this parent as parents, but actually provide evidence. They prove that the parents are this person and this parent and this other person. That's what we mean by evidentiary effects. Next slide, please. Yeah, something that it is important, and I've seen this is important in Parliament also, and which is important also at the Council level, is that the proposal specifically includes provisions which are strictly necessary, legally not strictly necessary, but that we think it is important to remind member states how they can use the public policy that they often invoke to say, I will not apply the law of another member state because the law of this other member state allows for parenthood by same-sex parents, and I don't allow that. So I will refuse to apply the law of this other member state. Or I will invoke public policy to refuse to recognize the parenthood that has already been established in another member state. All we're saying here is you cannot invoke public policy if that leads to a discriminatory situation. So if you refuse the recognition of the parenthood because it's the parents are same-sex, obviously you're discriminating against a child that has same-sex parents as opposed to a child that has heterosexual parents, and that would be contrary to the Charter. So we make a specific reference to the need for member states to keep in mind the Charter when they invoke public policy, which they can always invoke, for example, if they consider that fundamental rights have not been respected or that the rights of defense in a proceeding have not been respected. And finally, another important point is what we call the European Certificate of Parenthood, which is a new instrument created by the proposal, proposed by the proposal, which would be a document that would be uniform in all member states. If you wish, there's the birth certificate that proves that I have this person are parents, but that's a national document. The European Certificate of Parenthood, it would be a document issued by the national authorities, but pursuant to the regulation, which means it's not a national document, strictly speaking, because it has to be issued in accordance with the EU law. And in accordance with EU law, the document is gender neutral, which means it doesn't talk about mother and father, it talks about parent 1 and parent 2. Citizens can choose to request it if they don't want to request it and prefer to go around the union with a birth certificate. That's perfectly fine. But if they choose to get one, it has to be issued by the authorities. All the information in that European Certificate of Parenthood will be uniform in all the member states, and the effects will be uniform, because as you can imagine, birth certificates in different member states have different contents and have different effects, so that makes it more difficult for a child. If first shows a birth certificate in one member state, it can be accepted in one way, and then in another member state in another way. But the European Certificate of Parenthood will have the same information and will have uniform effects. And in addition, because it will be an annex, there will be a form for a European Certificate of Parenthood, which will be an annex to the regulation. It will exist in all languages, so that will diminish the translation costs. Now, as I'm running out of time, next slide, please. I wanted to mention before that we are discussing in Council, the Commission and the Member States are discussing. We've had already 8 meetings of 1 day each, so there's been quite a lot of discussion. We are still going through article by article through the first, what we call first reading, not in the sense of first reading as in the Parliament, just first reading meaning that we are reading it for the first time. And there's already been very constructive comments and discussions, and of course then there will need to be still another reading until there is an agreement among all the member states. Sorry, that I forgot to mention very quickly, just to remind everyone that the Court of Justice has said very clearly in the Baby Sarah case that the obligation for member states to recognize parenthood for the purposes of union law rights, which we already have. In that respect, the member states cannot validly invoke national identity or public policy, because the court has decided that recognizing the parenthood of a child that has two same-sex parents does not violate the national identity of any member state and does not violate the public policy on any member state. So we already have that very clear at case law level. For free movement rights, basically, for rights under union law. We are trying to get the same for the rights under national law, which is what mainly this proposal is about. Thank you very much.
Thank you, Maria. So obviously to try to bring more clarity in all of this so that the children are not so impacted by this, right? At the end of the day, it's a child, and that's why we want to talk to Laura Martinez Mora, Permanent Bureau of the Hague Conference on Private International Law. Laura, you have a presentation to make. You're ex-UNICEF, I noticed, specialized in children's rights and family law. Also keep in mind, please, that, that YouTube, please do put in your comments and questions in the chat. And for those of you here, you can go analog. You can raise your hand and press the button when we call on you. So please do put your questions together. This is a workshop. This is all about sounding everybody out, whether you're here or whether you're virtual. We want to talk to all of you. So, Laura, please.
Thank you very much, Chris. Good afternoon to everyone. And on behalf of the Permanent Bureau of the Hague Conference on Private International Law, in short, the ACCH, I would like to thank you for this invitation to be here today in the workshop. We have just heard about the European proposal, and today, this afternoon, I'm going to speak about the ACCH project, where we have been working as well in this field. Just for you, for the ones who doesn't know us, we are an international organization, and maybe we can change to the next slide. And therefore, our scope geographically is at this moment 91 members, that's 90 states from all around the world, and the European Union. And they are all members of the ACCH. And therefore, we are legislating on the same topic, but with much more diversity. Because, of course, we have many different legal traditions and systems, and as you know, family is very much dependent on culture, and of course this gives a lot of enrichment, many different types of families and ways of understanding family, but as well it has many challenges. And it's the challenges that Maria already referred to, so uncertainty, lack of continuity, inconsistency, lack of recognition. In other words, you may end up not having the same legal parents from one country to another. I'm just asking. Can we move to next slide? So we are, the mandate of the ACCH is to draft international treaties. And these international treaties, can you click, please? Deal with private international law. So Maria has already explained what is private international law. I tend to put my example. My mother is French-Canadian. My father was Spanish. I was born in Spain. One of my daughters was born in France, the other one in the Netherlands. My husband is Italian, and we live in the Netherlands. So just to explain, in families like this, I think there will be many here around here, but in families like this, which country is going to decide if you have a matter? Maybe we decide it's the Netherlands because it's the place of habitual residence who is going to decide on the legal parentage, but then which law is going to be applied? And then once we have a decision, how is this going to be recognized in the other countries? And then also something very important that we added that maybe, I think it's the same at the EU level, but we work a lot on cooperation. We believe a lot that cooperation makes the difference, and cooperation between states can really improve situation for citizens and children and people. Our legislative project goes on legal parentage, and it says generally. So I think that comes to what Maria has said, but then it says, including legal parentage resulting from an international surrogacy arrangement. And why did we specify this? Is because at the ACCH level, we started thinking about this topic in the year 2000, but at that point we had other treaties and other projects. And then it was in the year 2010 that we had issues regarding surrogacy. And issues regarding families that were moving, for example, from a state where the intending parents were both considered the legal parents to another state which will not consider them the legal parents. And it was not just about limping legal parentage, but as well because in some states, in the case of surrogacy, there is many abuses. And there is acute human rights problems. Therefore, our states wanted to say, should we do something? Can we do something? I just explained that we deal with private international law, so we are not like the UN, so it's not that we are going to modify the legislation of each state. But when you are going to recognize the legal parentage, will you be recognizing it if there was a sale of children? So there were many questions that were posed by our members on how do you deal. On the other hand, you don't want to discriminate. Maria also said it. So because you want that, doesn't matter how you were born, you're just born. And why is the child going to bear the fault of adults doing things against the law? So how are you going to deal with all that? So it's all these type of questions that we have to deal from a private international law point of view, but as well the discussions in our members is how do you enhance this recognition? Maybe a possibility is that states, if there is an international treaty in the future, maybe you can decide who is your partner. So if you like, that's something that we can do at ACCH level, I don't think here. But for example, states can say, okay, I want to work with you. So you're not going to work with anybody, but you're going to decide with who you're going to work. Next slide, please. Briefly speaking, we have been working in this since 2010, doing some studies, and then since 2016 to last year, we had an expert group, and this expert group was looking at feasibility. So feasibility of developing a treaty, and it has technical issues of private international law that are very tricky and difficult to resolve, but it has as well the understanding, the different understanding. For some, surrogacy can be acceptable, from others not. How do you put all these people together? That's a key question there. And desirability, it was clear for us since the beginning, because there is a problem, we cannot ignore it. We have to solve it, we have to do something. The key question here is, are we going to agree? If not, the situation will continue to be the same, so we need to agree. And this means that states need to agree and need to give some, they need to give in from one side or another. So we will have to see. And now we are turning to another, what we call, it's a more like high level, what's called a working group. This working group is not mainly by experts who can speak on their own capacity, but they come with the policy views of their states. And therefore, we are discussing the possibility of having an instrument on private international law, and we have to look at the scope and the content, and as well, they have to decide a bit in advance if we are doing something that can be approved by our members, but not only approved, we just don't want to have another convention. We want to have a convention that's applied. And that makes the difference, because it's not just having, with all the respect, lawyers drafting a new treaty. You want that it really has an impact in people. So,
Can you say, Laura, who's in the working group and who's in the experts group?
In the expert group, it's all our members. So we go to the first, in the first slide, the second slide, where we had the map, some of them, so it was 25 of them. Okay. So we had many here from France, Spain, Italy, USA, Canada, Mexico, Argentina, South Africa, Japan, Australia, Ukraine, Russia. Yeah. So it was all over. You need to be a member of our organization to be a member of the group. And for the working group, I cannot answer because we just convoke it. The first meeting will be in November. And we guess we will be the same ones plus more people. Plus. Yes. And yeah, the difference is that in our expert group, in order to move forward, we had to had the group and as well what we call CGAP, that's our governing body, decided that we, at certain point, that we needed to have two instruments, one convention on legal parentage and a protocol on surrogacy. Because surrogacy needed some specific treatment. Now we are going back of having only one instrument and deciding if surrogacy needs to be treated differently because it has some very specific scenarios. But this is all in discussion. Next slide, please. Possible aims, and I think it retakes what Maria said, predictability. You want to know what's going to happen if you move from one country to another. Certainty as well, continuity. You don't want to have different parents in different states. And then you don't do all this at all cost. You do it taking into account the human rights of persons concerned, because there is also international law, public international law treaties that we have always to respect. And for children, we have the UN Convention on the Rights of the Child. Therefore, best interests of the child should be a primary consideration in all the work that we do. Next slide. And maybe next slide. Next slide. I'm going to go over. I'm going to finish with this one and the next one. So I wanted to explain a bit what we are discussing today at ACCH level. So there is two ways of doing. If there is a specific chapter in an instrument for surrogacy, maybe not. That's our members who will decide. But if there is one, the key question is that I said that you want that when you're recognizing legal parentage, we are not going to establish all minimum safeguards for everything regarding to surrogacy. No, it's not our mandate. But if we recognize, we are sure that some things, especially if they were illegal, didn't happen. So how and when do you check this? You can do it in what we call a priori system. This will be something similar to what we had for the '93 Adoption Convention. That's a system where states get together before anything, before the child is conceived, and therefore you follow a procedure. This will give more guarantees. You can do more checks, but there may be more problems because states that have surrogacy don't want it because they have to change the way of doing it. And states who prohibit surrogacy don't want it because they understand it as maybe legalizing it. But at the end of the day, at least here in Europe, you have to recognize it. So that's a key question. And then, so this one was recommended in the expert group, but they say it's not feasible. We're not going to agree. So we go to a posteriori. So the posteriori is that states get together and start exchanging once the child is there. But at least you know that if you want your legal parentage being recognized under this treaty, you need to do things properly, because if you didn't do them properly, then it will not be recognized. And this is what we call a posteriori, and there's many different options to do it. And the last slide, please, no, next one. Yes, just to emphasize, I'm not here to promote, we are not, ACCH is not promoting surrogacy. We are not prohibiting surrogacy, and we are not unifying practices. I think this has to be very clear. There's some minimum basic things that will need to be done for the recognition, but we are not doing this, and this has to be very clear to everyone. Next slide, please. If you want more information, we have our email and website, and in the website you can find a full report of our expert group where it explains what I have just explained in more detail. Thank you very much.
Laura, thank you very much. And I just want to remind, too, the people watching on YouTube, please do put in your questions via the chat. Even those of you here who might be a bit bashful and you don't want to ask directly, that you're welcome to put that in the chat on YouTube. Is anybody here itching to ask a question? after these first two presentations? Anybody? Okay.
So clear presentation.
It's very clear, I guess. Yeah, all right. Well, I have questions actually coming in, let's see here. In view of the dangers to circumvent the regulation on the grounds of public policy, could the Commission, Maria, explain why there is a need from a PIL perspective to introduce the public policy exemption? Does that make sense? Yes. In view of the dangers to circumvent the regulation on the grounds of public policy. You got it? Okay. Try.
Well, thank you for the question. I'm not fully sure I've understood the question, but as you may all know, every instrument on private international law has to have, and that is a must, the possibility for a member state that has to apply a foreign law or that has to recognize something done in another country or in another member state has to have the possibility to invoke public policy. And that can also be because they don't want to apply the law of another member state that prohibits parenthood by same-sex couples. So, for example, it can be that if I'm the authority of a member state that allows in the national law parenthood by same-sex couples, because of the rules, the national law that, according to the proposal, I have to apply, it may be that it's the law of another member state, and in accordance with the law of that other member state, the child can only have one parent, the genetic parent, in the case of same-sex couples. I would have then the opportunity to say, sorry, I invoke public policy, because for me this is discriminatory, it's not respectful of the members of the fundamental rights, so I do not apply this specific provision of the foreign law, and instead I apply my own law, and I establish the parenthood as regards the same-sex parents. Or the same, it could be that there's a member state that has established parenthood as regards, let's say, with assisted reproduction technology. Let's assume that the member state that has to recognize that parenthood somehow knows that, which is another issue in practice, whether they would know. But anyway, let's assume they know, and they say, sorry, I cannot recognize this parenthood because I have sufficient grounds to believe that the fundamental rights of the spouse or the partner of the person that underwent assisted reproductive technology did not agree, did not consent to this, and so I don't recognize. So there always has to be the possibility to invoke public policy. What the proposal does not want is member states to invoke public policy as a general blanket against, for example, children whose parents are same-sex or children that have been born out of surrogacy, just like that. Oh, this child has been born out of surrogacy in another member state, so I don't recognize that the parenthood as established in another member state, or that child has had two parents of the same sex established as parents in another member state. I don't recognize that because they are same-sex couples. Why? Because in these cases, there would be a situation of discrimination against the child. And on the other hand, what there needs to be is the possibility for, in specific cases, when there are doubts that fundamental rights, like as I mentioned before, the agreement by the spouse of the person that gets inseminated artificially, for example, or, as I said, defense rights, like, for example, if there has been a case, the recognition has been, the parenthood has been established in another member state in a court case, and there was someone that was affected by that case and was not heard. That's what we call rights of defense. So there has to be possibility for a member state to invoke public policy in very specific cases when there's suspicion of this basic matters, non-respect of fundamental rights and non-respect of defense rights. But what we are saying in the proposal is you cannot invoke it as a blanket against certain situations because that would be discriminatory and against the Charter. We do not think and we do not see why. I'm not sure I understand the point of circumvention because of public policy. It has been argued that depending on which law applies according to the regulation or according to which member state has the power to establish parenthood, that depending on which criteria we decide, for example, state of birth, the law of the state of birth, or the country whose courts have to establish parenthood, and it's the courts of the member state of birth. It has been argued that in these cases, some people would then go to a member state where parenthood by same-sex parents is allowed, give birth there, so as to have the parenthood as regards the two same-sex parents established. Well, first of all, we in the Commission, we do not see this as circumvention of anything, because here we're talking about fundamental rights. And when we talk about fundamental rights, we do not think that it is illegal or against the spirit of any law to go to a member state where your fundamental rights will be respected. So for us, this is for the Commission, this would be what is called forum shopping. It would not be a case of circumvention. It would be the possibility that already exists today and which does not change with the proposal for two gay mothers whose nationalities, their countries do not allow same-sex parenthood, and who the two mothers live in a member state where does not allow same-sex parenthood. For us, there is no circumvention if they go next to the neighboring member state and give birth there, so that where they allow parenthood by same-sex parents, so that the two mothers are established as parents. We understand that some member states may consider that a circumvention, or that they may consider this as an abuse of some kind of. For us, this is no abuse, because we're talking about fundamental rights. We're not talking about economic rights. We're not talking about tax evasion. We're talking about fundamental rights. So I don't know if that answers the question of the person, but we understand that there are different views in different member states.
Yeah. Okay, let me go to, I have another question here for Laura. Could the parenthood regulation avoid a situation of statelessness like the baby Sara case? Maybe you can explain a little bit the baby Sara case too, right?
I think that would be more for Maria.
Yeah?
Yeah, because it's about the regulations.
Okay. Maria?
Yeah, this is about union case law. So poor Laura doesn't deal with union case law. So, yeah, well, I know there are people in this audience that know the ins and outs of the baby Sara case. So I invite them to participate. Nationality is an area that falls under the treaties, under the competence of the member states. And so member states decide how the children or people in general get nationality. So in some member states, nationality is acquired through what we call the jus sanguinis, through birth, not through birth from one of the parents, the mother or the father, or both, or either. In some other, for example, in the US, you may know that if you're born there, you become a national. In Europe, it's not like that. Your mother or your father or either has to be a national in order for the child to become national. The baby Sara case, in the end, it has been resolved contrary to the interests of the mothers by using the fact that the child did not have the nationality of the member state that had to recognize the parenthood as established, so that the Bulgarian Supreme Court has decided that the child did not have Bulgarian nationality, and so that they didn't need to recognize the parenthood as established in Spain through the birth certificate, and then obey the case law of the court to recognize the parenthood as established in Spain. This is a smart way around the problem that the Supreme Court in Bulgaria has used, with which we don't agree much, because the courts that were requesting the opinion of the Court of Justice made clear that the child there could be an assumption that the child was Bulgarian, and it is on this basis that the Court of Justice issued its ruling that the parenthood had to be recognized. Now, if the Bulgarian authorities consider that the child is not from another member state, and so they are not obliged to recognize parenthood, well, then that's, I guess, their prerogative, because only them can establish nationality. But I know that there's someone here who will want to apostille or my comments.
Okay. All right, Maria, thank you. I think, Laura, you had something to add to that. I mean, the whole idea about
A small
yes,
question to
go ahead.
Laura.
Yeah.
Is it possible to organize the countries that are discussing this problem by clusters, considering their opinions, or?
Yes, you can. Yes, yes.
Can you?
Yes, of course. Yeah. I can fully make a picture. So we had some countries in North America who will have more, not only in North America, as well others in Asia, that at least at one point where surrogacy was possible in a commercial way. And then other countries where you, well, we have to see, I'm focusing on surrogacy, but I should be focusing maybe on legal parentage more generally. So in legal parentage, more general, yes, of course, it will be depending the legal tradition, family traditions of the different states. So some it will be still be the mother, father, and that's it. And others, we will have some countries where even it is possible already to have more than 2 legal parents. So have like 3 legal or even 4 legal parents. So we had some of the states that were participating. It's not many, but it's starting more and more. So we had that. Then we did our best, and we hope that for the working group, we will have as well some countries with Muslim background. Because it will be very important to have Sharia law as well, countries that are represented, and we also take into consideration their ways of and their legal traditions. If we look at surrogacy, yes, there were different, they were from countries where it is not regulated, to countries where it is regulated and it's possible, it is possible in a commercial way, and countries where it is regulated but it's only possible in an altruistic way. But this is also terms, commercial, altruistic, are also tricky, because in some countries where it is altruistic, you can reimburse all the costs, but all the costs, yeah, what's the measure in there? What can you put in there? So that's quite very different. As well, something that I wanted to say, and that came a lot in the discussions, is that in Asia specifically, we have seen some countries where it was possible to do surrogacy deciding to close surrogacy or to limit surrogacy after many abuses. So in some, they have decided not to do surrogacy or only at domestic level. So we have seen it's all different possibilities, and that's the most challenging part.
Yes, Maria.
Yeah, thank you. Just because we're talking about surrogacy, I would like to clarify, because this is an issue that is recurrent both in Parliament and in Council, that the proposal of the Commission does not, as Laura said, as regards the convention that is being discussed at the ACCH, does not impose on member states whether to prohibit or whether to allow surrogacy, because as you may know, family law, the only competence that the Union has about family law is family law with cross-border implications. It doesn't have competence on substantive family law. Substantive family law, for example, covers matters such as how family is defined, which requirements are necessary in order to establish parenthood. So on these issues, the Union doesn't have competence, so the proposal doesn't touch on all of this. There are 3 member states that currently, well, 2 that currently govern surrogacy, and 1 that will soon. It's, you may know, it's Greece, Cyprus, and the Netherlands in the near future. And the surrogacy rules of all these 3 member states are, as Laura said, non-commercial or altruistic. What the proposal is saying is that if surrogacy is carried out under the law of one of these 3 member states and the 2 intended parents are established as parents under the law on surrogacy of Greece, Cyprus, or the Netherlands, then the other member states, all they need to do is to recognize that parenthood, because otherwise the child no longer has the same parents in another member state. So what we are doing with this proposal only is requiring the recognition of what another member state has done. And this includes, as I said, domestic adoption, so that member states should trust the procedures for domestic adoption of each other, that they will all do things as they should be done, and that when a child is born out of surrogacy under the laws of another member state, that they should also recognize surrogacy. But it is not about, I insist this is important, about permitting or allowing surrogacy, in particular in the member states where surrogacy is prohibited. We will make sure that the final text of this instrument does not interfere with the decision of each member state not to allow or to allow surrogacy. That has to be made clear, because often surrogacy is used as a very big reason to oppose this regulation. And it is a fact that, yes, we would be requiring that the parenthood as established after a national surrogacy in a member state be recognized. And as you may know, there is this case law of the Court of Human Rights in Strasbourg that already requires the member states of the Council of Europe, which includes the Union member states, to recognize the parenthood of a child born out of surrogacy abroad. So there is already case law of the Strasbourg Court that requires member states to recognize parenthood established abroad. So that already exists. What we would do under the proposal is, if you wish, we would go a bit farther, because under the case law of the Strasbourg Court, there needs to be an adoption of the child. But under the proposal, which would be based on mutual trust, it would be a recognition under the rules of the proposal, which are simpler than adoption. So that would be the difference between the two. And if I may, just very incidentally, because I always often get that, but why is the Union acting if there is already an international project? The reason is that if it is, as you know, quite difficult already among member states to reach common ground, you can imagine how not easy it is at international level between Australia and Saudi Arabia and the Netherlands. So you can imagine. And also because we don't know exactly what the scope of what this convention may be. We, with all due respect, doubt that the scope of the convention can be as ambitious as the regulation. If ever there is a convention, of course, among the member states, the proposal would take priority. The regulation would take priority. But vis-à-vis third countries, the member states then would be obliged by the rules of the international agreement. But among the member states, the regulation would apply. Thank you.
Thank you, Maria. If we can keep the answers rather tight so that we can move ahead, it would be great, because at this point I'm running behind. Maria, did you have something to add here? Are you okay? Maria? No, because I saw you push the button. Okay. Yeah, exactly, yeah. Okay, Laura, you had something very briefly to say?
Oops. Thank you, Maria, to remind me the challenges of, that we are facing. We are fully aware of those challenges, but as well, it's quite incredible that members at HCCH really are eager to do something. So we are every year in our general meeting, it's in March, we are really surprised to see, no, we need to do something. What we need to do, that's the question, but there is also agreement, our ability is very much there. And I just wanted to say that, as well as Maria said, we are not regulating, we are not telling our members what to do, as I said in my last slide. It's each state will decide, and we are not changing. This is national law. We are not changing that. We are ensuring that if there is legal parentage already established, that you can recognize.
Because we realize this is potentially a political hot potato in certain countries, right? Now, we do want to move on to the next panel, but I'll take quickly this question over here. And the whole panel is staying on the whole time. So anybody can answer anything. So please, name and question.
Yes.
Name and title.
Yeah, good afternoon. So I had a question. We started by saying that there is no place for discrimination in the EU, and I think that the proposal is quite clear, wants to make the rights of rainbow families travel with them when they exercise freedom of movement. I was wondering if the proposal also ensures that discriminations don't follow rainbow families when they travel. And for that, I will take the very specific example of, in Belgium, filiation laws are not the same for everyone because they're based on the country of the nationality you have. Meaning that in Belgium, if two mothers go through an IVF, they're all allowed to do so. At the birth, the co-mother will not be recognized if she's Bulgarian, but she will if she's Portuguese. She will not if she's French. She will if she's Spanish. So I was wondering if also it is covered in the proposal.
Okay, who would like to answer that? I'm not sure who's... Maria, briefly, please. Yeah.
Yeah, this is not about carrying with you discrimination. This is because currently each member state decides how the parenthood is established in cross-border situations. In your example, it's Belgium, Bulgarian, so cross-border. And then each member state says, okay, in a cross-border situations where I need to establish parenthood, which law should I apply? And based on what you say, in Belgium, it would be the law of the nationality of the mother or the spouse, whichever. So the Belgian system in its laws says that it's a law of the nationality, and that's why this happens. In the proposal, we would say, we are discussing this with the member states, but in the proposal it says the habitual residence of the mother of the person giving birth, which means if I give birth here in Brussels during a trip, but in fact my residence is in France, the authorities in Belgium will need to apply French law to establish the parenthood of the child that I give birth here in Belgium. That's what private international law is about. Now, in our proposal, you may have seen, this is already technical, but we say, okay, as a rule, it is the law of the habitual residence of the person giving birth. However, if as a result of the application of this law, only the parenthood of one parent is established, i.e. the genetic parent in the case of a same-sex couple, then these other two additional laws may be applied either by the authorities or by the citizen going to another member state competent. And that is the law of the nationality of either mother or the law of the member state of birth. So, for example, if there is two mothers that live in Bulgaria, one is Bulgarian and the other is Belgian, and the one that gives birth is the Bulgarian mother. If Bulgaria, then, because they live in Bulgaria, the Bulgarian authorities would apply Bulgarian law. And accordance with Bulgarian law, it would only be the genetic mother, but not the other, not the spouse. Let's assume that they got married in Belgium. However, the proposal gives the possibility, well, first to the authorities, if they want to apply the Belgian law, because it's the law of the nationality of either parent, so the law of the other mother, to establish the parenthood of the second mother. But if they don't want to do that because that's contrary to their own national system, that mother can go then to the Belgian authorities, and because the mother has the nationality of, under the law of the nationality of either parent, she can go to the Belgian authorities and say, can you please establish parenthood in regards of me? And then what may happen is that either that there are two birth certificates, one issued by the Belgian authorities as regards the mother that gave birth in Bulgaria, whose motherhood was established in accordance with the law of the habitual residence of the person giving birth, which is the rule. And then the Belgian authorities will issue another birth certificate as regards the second mother, saying that that spouse, non-genetic mother, is also a parent of the child. Or, what I understand from our experts in Belgium, they can actually issue one single birth certificate saying the mother established in accordance with the law of the habitual residence of the mother giving birth, established by the Bulgarian authorities, and the mother whose parenthood has been established in accordance with the law of the nationality of either parent by the Belgian authorities. So the proposal wants to make sure that whatever happens today, please all be aware that this happens today. If I can be so blunt, this example happens today, if I can be so blunt, and I don't mean to name and shame everyone, if there is a couple of Poland and Hungarian mothers that live in Slovakia and they want to have a child, their nationalities don't allow same-sex parenthood. The place where they live also doesn't allow same-sex parenthood, so they go to Germany. And there in Germany, the parenthood is established as regards both mothers. That is happening already today. What the Commission absolutely didn't want to do was to propose something that would go back, that would remove rights that same-sex couples already have today, because today every member state has its own rules. So in order to ensure the protection of the fundamental rights, gay couples sometimes try to see where their fundamental rights will be best respected. And they use this disparity. What we didn't want in the proposal was to, by applying the same rule that everyone has to apply, and therefore avoiding this current disparity, to prevent them from doing what they can already do today, because then we would be losing rights for same-sex
That's right.
couples.
You don't want to go back. You don't want to go back on this thing.
Back.
I got to move ahead, Maria, really,
And
I
that
do.
at the end protect
Maria,
the
please.
child, because the mess is installed today and the child is unprotected.
It's complicated. We would like to move to the next panel. And this is now a critique. We presented you the issue. In fact, we did present some of the complications involved as well. But let's move to the panel on a critical assessment of the proposal. And one person who's very well versed to be able to do this is Alina Trifonidou, who is professor of European law at Neapolis University in Cyprus. And Alina, are you with us? Can I hear you?
Yes, I am. Yes.
Ah, fantastic. Now, I know you have some slides to show, and you know, I did have a sneak peek. And obviously, you think that this is obviously a step forward. This is important. It focuses on the child, but there are gaps. Let's talk about it.
Thank you very much, and thank you for the invitation to be here today. I want to apologize, I couldn't be there in person. So I have been asked to speak initially for 5 minutes. Now I have been told I have 10 minutes to provide a critical assessment of the proposal. So what I'm going to speak about is, first of all, I'm going to say what are the good things that are going to be achieved by this proposal if it becomes legally binding. Then I'm going to briefly speak about the gaps in protection that will persist even if the proposed regulation will come into force. And then I'm going to speak very briefly about some recommendations for improvement of the proposal, but also there are some things that can be done once the proposal becomes legally binding, if it becomes legally binding, that can make its application smoother. So next slide, please. Yeah, so the proposed instrument is very ambitious. It will take protection at a much higher level than than what is currently provided under EU law or even under human rights law in Europe. It's a very positive step towards a wholesome EU solution to the problem of non-recognition of parenthood, as this was identified in the previous panel. First of all, I would like to emphasize the fact that it will provide a wholesome solution, a complete solution. As Maria Vilar-Badia mentioned previously, the solution that currently exists at EU level with regard to the cross-border recognition of parenthood, which has been provided judicially with the Baby Sarah case, requires the cross-border recognition of parenthood only for the purpose of the exercise of EU free movement rights by union citizens. But this proposal this instrument will require cross-border recognition of parenthood for all legal purposes. So once the family is within the territory of another member state, the parenthood of the child will need to be recognized for maintenance purposes, for medical care purposes, etc., etc. So this is really important because it goes much further than what has been required, what is currently required through the court case law. The other way that this instrument goes further than what is currently provided is that it will not be simply a free movement instrument, so it will not just require the cross-border recognition of parenthood in order to ensure that union citizens can exercise their free movement rights, but it's simply an instrument that wants to ensure that parenthood that has been established in one EU member state will be recognized everywhere in the EU. And this, again, I emphasize, not just for EU free movement purposes. So it goes much further than just free movement. It's a child-focused instrument, and the primary focus of this instrument, I would say, is to protect the fundamental rights of the child. So the best interests of the child and the fundamental human rights of the child are the main focus of this instrument. And this is why it doesn't draw any distinction among children depending on how they were conceived, how they were born, and also it applies to children irrespective of whether the child himself or herself or the parents of the child hold union citizenship. So, in other words, this proposal will offer a solution with regard to the issue of cross-border recognition of parenthood, even with regard to families that are comprised exclusively of third country nationals, meaning non-EU nationals. Also, practically speaking, this instrument will enhance legal certainty and will, as a result, save time and costs both for families and for national judicial and administrative authorities involved in the procedures for the establishment and recognition of parenthood. So, as was mentioned in the previous panel, currently, if a family needs to have parenthood recognized in another member state, usually if there is an initial refusal by the authorities, then the next step is for them, if they can afford it, to go to the court. With this proposal, with this instrument, this need will no longer exist, because the instrument itself will determine which member state, which national law, which member state courts can determine the establishment of parenthood in cross-border situations, and of course it will require cross-border recognition as such. So it will not anymore leave it to the member states to decide private international rules. Next slide, please. Okay, now, although the instrument will, in its current form, achieve a lot, and as I said before, it's a very positive, very ambitious instrument, of course there will be some gaps in protection that will remain even if it will come into force. So the first one has to do with its application to member states. We currently have 27 EU member states. The instrument will not apply to Denmark, not because there is something wrong with this instrument as regards Denmark. It's not because Denmark opposes it, but rather because Title 5 of Part 3 of the Treaty on the Functioning of the European Union, on which this proposal is based, does not apply to Denmark. Also, there is a second member state that for this one, we have a question mark whether the proposal will apply. It's Ireland, that by default measures originating in this part of the treaty do not apply to Ireland unless it exercises its opt-in option. So if Ireland decides to opt in, then obviously it will apply to it. If not, then it will be a second member state to which this instrument will not apply. The other point I would like to mention in terms of this being a gap is that the proposed regulation has a limited territorial scope, in that it only applies to situations where parenthood was established in a third country. So in situations where parenthood was established, let's say in the US or Canada or India, then the instrument will not apply, and so there will be no requirement that parenthood established, for instance, in the US will need to be automatically recognized in one of the EU member states. And thirdly, the other gap is that it includes no explicit mention of the need to protect the child's right to know its origins. Of course, the proposal mentions at many parts that the rights of the child and the best interests of the child should be a primary consideration. And of course, we know through case law under the European Court of Human right, that the child's right to know its origins, it's part of the child's right to private life. So it's all there somewhere, but there is no explicit mention in the proposal for the need to protect the child's right to know its origins with regard to all procedures and all instances where the parenthood of the child is established or recognized. So this is something that could be considered a gap. Next slide, please. Okay, so in terms of recommendations, the first point I would like to make here is that, as you may have gathered already, this is a very technical instrument. It's a private international law instrument, so it's very technical, it's very difficult to understand, even by lawyers in many occasions. So it is recommended that once the proposal comes into force, it would be good for the Commission to issue guidelines in simple language, giving more information in more detail regarding the application and enforcement of the instrument. And also it is recommended that national judges, civil servants, legal practitioners, basically anyone who will need to apply this instrument should receive training in order to be able to interpret and apply the regulation uniformly. The public policy exception, which has been mentioned in the, which was mentioned in the previous panel, it must be ensured. I mean, before going to say what must be ensured, as was already noted in the previous panel, a public policy exception is a staple. It's always there in private international law instruments, so it's not something that can be discussed as to whether it should be included or not. It's there. But what must be ensured is that when member states will try to rely on it in order to depart from their obligations, from the rules laid down in this instrument, that it will be ensured that indeed, as mentioned in this instrument, the public policy exception is not used in a way that violates fundamental human rights, contrary to the Charter. Then, as I noted before, the right of the child to know its origins is nowhere explicitly mentioned in this proposal. Obviously, the proposal itself is not the place to insert a very detailed reference to this right, but this could be mentioned just in 2 lines somewhere in the proposal, just to emphasize the child-focused, the child-centered nature of this instrument. And then, of course, as has already been mentioned, the biggest challenge for this instrument, of course, is to achieve unanimity in the Council. Well, if it's not achieved, then some say, well, the next step is enhanced cooperation, but we have to remember that enhanced cooperation means that not all member states will be bound by it, so it defeats the whole purpose of this attempt to harmonize the private international rules of the member states exactly in order to ensure that children are not deprived of their parents whenever they move within the EU.
Alina, isn't that kind of a catch-22? It's a difficult situation where you don't want to water it down too much, but you want to get unanimity. You got to find that fine line, right?
Exactly. Obviously, compromises will probably have to be made. So the big question is which compromises will be made to ensure that it's not watered down to such an extent that it becomes pointless. So that's what I had to say. Obviously, I will be more than happy to answer any questions. Thank you very much.
Okay, Alina, that's great. And once again, an appeal to all of you for questions and all of you listening and watching from afar. You can put things in the chat. I've got some here. I want to pitch some out to some of the panelists. But via YouTube, the YouTube chat, you can put in your questions and comments and let's see them. You can also tweet #parenthood. Let me go to a question. Mathieu asking, how many children? I'm sorry, yeah, that's true. I do have to go back. I have one more speaker. I'm so sorry. Yes. Before we go to those questions, let's move on to Catherine. Sorry about that. Catherine Hugendubel, Advocacy Director of ILGA Europe. That's the International Lesbian, Gay, Bisexual, Trans, and Intersex Association, part of a global federation of 1,700 rights groups in over 160 countries. It's a very large organization, global.
Well, we're part of the global
You're
network.
part of that, you're Europe,
So
yeah.
I'm Katrin, I'm the advocacy director of ILGA Europe, actually. So we're the European Central Asian LGBTI network. So we're in 54 countries and we have over 700 member organizations. So still quite a lot, not that many. I want to make a few comments, I think, just to put it into context and kind of what it means. And if I heard the start of your question right, it was about how many people. So I think I'm going there a little bit, but let's see. I just also want to say that this is a file we work really closely with other organizations on. So I just want to mention we work, for example, with COFACE, who is the European Network of Families, but also with Eurochild, because this is really about the best interest of the child. We were asked to do a critical assessment, and I think whereas, we fully agree also with Alina's assessment of this is a very ambitious proposal by the Commission, and I think we, as such, don't have so much. We want the proposal to go further. We obviously see this as one piece in a puzzle of what still needs to be done for LGBTI people and their families within the EU, looking at freedom of movement and cross-border situations. A lot of gaps remain. We have the Coleman judgment from the court in Luxembourg, for example, which is talking about freedom of movement for same-sex couples, which is still not implemented by Romania and not respected by other countries. We have a new case coming up at the court in Luxembourg about legal gender recognition, so the ability of trans people to move freely across the EU. So there are many gaps, but we're not expecting that proposal to tackle them all, and we're actually really quite happy to see the ambition in tackling the question of the best interest in the child and parenthood recognition in that proposal. I just want to say, because the term of traditional families already came up, and I think it's really important to say rainbow families exist, they are here, they've always existed, people have always found ways to actually found their families. And the question is just, are we recognizing them? Are we guaranteeing full rights, or are we discriminating and actually taking away rights from the children and from the parents? It sounds really obvious, the quote from the Commission President Ursula von der Leyen, if you're a parent in one country, you're a parent in all EU countries. I think everyone who is a parent knows that that feeling of being a parent doesn't go away, the emotional bond doesn't go away, the care responsibility doesn't go away, but unfortunately, your legal rights and your legal bound to your child can still go away when you move across the EU today. And I think that's what is really important to tackle here, because it has real life impacts, right? If I'm not legally recognized as the mother of my child, I cannot make medical decisions, for example. So a same-sex couple going, I don't know, on holiday to another EU member state where only the biological mother is recognized. Imagine the three of them are in an accident, something happens to the biological mother, to the child, the non-biological mother cannot take a medical decision for the child in that situation. Now, it's just important to take it into consideration. And questions about education of the child, heritage was mentioned before. So there are many real-life impacts. There are examples we know, for example, about an Italian-Danish couple living in Copenhagen. The Italian biological mother then asked the Italian authorities how to register her family, and the answer she got was, it's best to say that you're a single mom. Well, best for whom? Maybe for the authorities, because that causes the least problems. It's definitely not best for the family, and it's definitely not best for the child. And this answer is 10 years ago. So we know the political context in Italy at the moment. The answer would be, I think, even more discriminatory at the current moment of time. So coming to the question of, how many are affected, there is an estimation from the Commission, from the needs assessment. We know cases, there have been cases litigated in Strasbourg, in Luxembourg, but across the EU. But actually, most of the cases we don't know, because I think what's also important to keep in mind is that people adapt. So people decide on an everyday basis, actually LGBTI people, but also rainbow families, on an everyday basis, consciously or unconsciously, they make decisions what they can do and what they cannot do, what's safe for them and what's not, but also what's possible for them and what's not. And so the most normal thing, the fundamental right of an EU citizen to move freely across the EU, to work in another member state, to reside in another member state, for them is just often not a possibility. So they rule it out from the very beginning. They adapt, limiting where they go on holidays. They adapt where they decide to live, and that affects life choices, that affects career opportunities, that affects your ability to live with your broader family, for example. It really has many implications. So to come to the actual proposal, as I said, I think we're really happy with the level of ambition of the Commission in that. We're also really happy that ourselves, but also, for example, NELFA, which is the European Network of Rainbow Families, were consulted in really early stages to really make sure it would make an impact on the real life of people. There are a few things that obviously are being very much discussed at the moment. I just want to say 2 words about that. One thing is, and it came up already, on the multi-parenting and whether that's recognized or not. For us, again, it's not about steering what member states do or what they don't do. But if one member state recognizes more than 2 parents, that family shouldn't have to choose when they're moving to another country which of the parents are the 2 that will actually be recognized. So we should make sure that, as far as we can, the proposal on the table stays neutral in just talking about parents and does actually allow the full recognition of parenthood from one member state to the other. The discussion around surrogacy, and a lot has been said, so I don't want to go into details, but again, it's really not about that. It's not about changing national level regulation of surrogacy. There is a requirement from the Court of Human Rights in Strasbourg, the European Court of Human Rights, to actually ensure parenthood recognition on national level of children born through surrogacy. It is about the recognition of parenthood, not looking and not discriminating based on how children have been conceived. And I think that's how we should be looking at it moving forward. What needs to be done? So we're here to work very closely with the European Parliament in moving forward, but I think it's also really important to say, and it's a call on everyone in this room and everyone listening in, we really need to work with member states on kind of embracing that proposal. Maria already said it, there are long discussions. I think there are a lot of technical questions. So we really want to come up with the maximum number of member states moving forward. So it's about talking to your governments to understand their position and to then kind of in conversations to clarify technical questions that there might be. Looking forward then, if enhanced cooperation is a solution or not, it's definitely not the solution we're looking for, but I think we need to stay constructive in moving forward. So I stop here so that we still have time for the discussion. Thank you very much.
Yeah, thank you so much, Catherine. And yes, we have hundreds out there connected on YouTube, and we'd love to hear your questions. Anybody here who would have a question, please raise your hand. You can go analog on that one. This is the sort of the picking it apart, the critical side of it. I have a question actually for Alina, and you mentioned that that Ireland has opted out and Denmark is not in because of the arrangement between Denmark and the European Union. But do you get a sense of whether those countries could become part of this? These guidelines. Could Ireland opt in? What do you think?
Well, as a legal academic, I'm not sure I can really answer this question because it's more of a political question. Again, I think it will all depend on the negotiations in the Council, so it's not a yes or no question, and definitely Ireland is not one of the member states that I would think that they are directly opposed to the instrument or some basic elements of the instrument. So I think it will all depend very much on the negotiations.
Okay, very good. Any other questions out there, please? Yes, sir.
Can I ask you a question? It's going to be very short. It has been said that, and we
Mr.
all agree.
Mavridis, is that what you, okay?
Yes, Mavridis. It has been said that nationality, it is a competency of the member states, which I guess we all agree on that. Some member states have a very clear policy that they don't provide or they reject a priori any citizenship to a child given that one of the parents entered illegally into the country. The question is, are there any exceptions first, or is it clear and square? And if there are any exceptions, what are those? Thank you.
Who would like to, Maria? Oh, okay, Maria, okay.
Sorry. Yes, thank you for the question. This issue has been discussed with the member states, and no one intends to weaken the national laws of the member states to avoid fraudulent, if you want, attempts to have parenthood recognized to acquire residence. In any event, if this is done directly from a third country, so if the parenthood, if I understand your case correctly, is it like, for example, the parenthood would be established, let's say, in France, and then that would travel to Belgium? Is that your situation, or is it?
Let's say with a third country. Someone, one of the parents came from a third country to a member state.
So a third country person comes to a member state and then some fraudulently acquires parenthood. Is that?
Can you put your mic on?
Can we talk this later on, maybe between us?
Sure, but just so you know, we are aware there's this problem. Neither the Commission nor the member states, well, the member states, they will speak for themselves, but the Commission in no case intends to facilitate any, if they are fraudulent, if they are not fraudulent, if it's, let's say, if,
Fraudulent, what action is fraudulent?
I understand, because that's something that was raised by the member states, not by us, that...
The entering?
No, well, the entering is not a justice issue, would be a home affairs issue, and each member state has its own immigration laws. But then I understand that sometimes it can be that a third country person is presented as the parent of some EU national, not being, for example, the father, but not really being the father, so as to, well, by being the father of the child, perhaps then being able to exercise free movement. You were worried about immigration here, or no?
No, my question, I thought it was very clear, but it wasn't, obviously. Let's stay with the fact, one or a few persons from a third country enter illegally, take it as given, illegally into a member state. And then that person from a third country gets into a marriage, have child with a European citizen.
Well,
but the member state has a very clear position that no citizenship to anyone from a parent from a third country who enters illegally into the member state.
I see. No, but our proposal has nothing to. Our proposal has nothing to do with that. That it doesn't touch at all upon how member states grant nationality, because it could be that they enter legally. It also wouldn't affect that. So nationality is nationality is a right derived from parenthood sometimes. sometimes, like if a woman has a child in a member state and the mother is from for example, I have had a child here, I'm not Belgian, so my child has, my nationality doesn't have Belgian nationality because that's how nationality is acquired here. But I mean, we don't touch on this. I mean, being a right derived from parenthood, it is a right that we're saying parenthood as established in one member state should be recognized in other member states for the purposes of rights and the union law. So if the parenthood established in member state A then they move and it has to be recognized in member state B, and under member state B, when you are a family, you have a right to some family allowances or some tax cuts or some, I don't know, discounts on transport or whatever. You don't import from the member state where your parenthood has been established. Let's assume that the parenthood of my child has been established in Belgium. And here, being a family, or me being a mother, or a single mother, or with my husband, or with my same-sex couple, I'm entitled to whatever rights. Fine. That's something that only Belgian law decides. Then I move to France. We require France to recognize the fact that myself and my spouse, be it same sex or different sex, be recognized as the parents. But then the rights that we have in France, only France decides. So it can be that I no longer have right to a transport discount, or it can be that I have right to much smaller family allowances or much greater family allowances. The rights derived from parenthood and the national law stay under national law. All we say is recognize the parenthood, because that has effects. If you recognize the parenthood, then you have rights under national law. But nationality, we don't touch on that.
Right. Yeah, I'm sure you can discuss that further after. We have a few short minutes left for Q&A. Any other questions out there? I have a few here from YouTube. One is from Mathieu. How many children from cross-border rainbow families are currently deprived from their rights? And which are your sources? I mentioned that one figure. I think it's from Alina's study, or is it from the Commission? 2 million. Yeah, 2 million. Yeah.
Sorry, just very briefly. So, okay, in our impact assessment, we calculated, with the help of a contractor that made all relevant calculations, that there's currently, based on Eurostat statistics, around 2 million children in cross-border situations. In cross-border situations. That means that they may need to have their parenthood recognized, and they may have problems. So that's, in principle, the number of children in a cross-border situation. Now, we have also calculations that show, that estimate, based on totally verified assumptions by economists of the Regulatory Scrutiny Board of the Commission, that show that around 103,000 parents and children of same-sex couples are finding today difficulties with the recognition of parenthood. So the estimation is based on actual data, but on the basis of some assumptions, which are totally plausible.
Okay, so yeah, Eurostat. I mean, you can't dispute that, right? That's
Eurostat
what
for
we
the
use
2 million.
as the
Yeah.
Rosetta Stone of, yeah, right.
Yeah, because as everyone can understand, there's no data of, there's no data, statistical data in any country as to how many same-sex couples or people there are, because people say what they want to say. And not everyone feels entitled to ask citizens for this information. So, but there are lots of studies and there are lots of estimations of how many gay couples there are, how many kids they may have, etc.
I was going to ask you, Catherine, because there are a lot of numbers out there that maybe we don't know about. It's not, right?
I don't want to add a number, but I just want to repeat what I think I said before, which is, if people think the estimation of the Commission is too high, it is actually based, as Maria is saying, on Eurostat, and it's based on families in cross-border situations. It's really important to keep in mind how many people are not even putting themselves in cross-border situations because they anticipate that it would cause huge problems for them. And they're not included in those 2 million. So let's just, if the figure is solid, and it's definitely much higher.
Yeah. In any case, it's a lot of people. It's a lot of children that are involved.
And it's a fundamental right.
Yes.
Exactly. Thank you for those two precisions, Catherine, because it's true. We are fully aware that we are not including the deterrence effect, which I mentioned in my presentation. And as you just said, Chris, also, when we talk about fundamental rights, quantities become relative, yeah? Because where do you put the bar? Okay, if only 5 people have their fundamental rights, that's okay. No, so that's not. But anyway, based on hard data, there are already above 100,000.
Right.
Yeah, so.
Okay, before we wrap this up with final comments, I have another question. And if there's anybody out there who does have a question to pose, this is your moment. Or critique, yeah, this is a workshop. We want your feedback. In view, wait a minute, hang on a second. We have, feel free. During the consideration of the draft report in committee this Monday, this week, the RE group, that's Renew, suggested to introduce a presumption of acceptance of the European Certificate of Parenthood, that's part of that proposal, to ensure that by default, parenthood is recognized. What do you think of this? What does the panel think of this? Who would like to comment on that?
Well,
and please keep it brief.
Yes, I don't want to speak for the Parliament because I think they are still considering amendments. And please, I speak under control of the rapporteur, but the deadline for amendments is the 14th of July. And it's true, I was there, so I heard that proposal. The Parliament will study it, and then we will study it once it's made. It's not totally out of the blue. It seems to be a reasonable proposal, but we also don't fully yet grasp exactly what it means. But the Parliament will.
As I said during the meeting with the committee, we are waiting for the proposal. It's an oral proposal. I've not seen for the moment the details, but we are waiting for it in order to consider.
Very good. I think, Catherine, you had something to add here.
Yeah, I just wanted to add that I think the criteria any proposal like that needs to be evaluated against is really legal certainty. It's about reducing administrative burden, reducing costs, and insecurity of people. I think that's what the European Parenthood Certificate is trying to do. And I think any adjustment of that really needs to look at those 3 criteria that are crucial for people's lives.
And of course, all the costs we can reduce are very important. As I said before, it's not only to create rights, it's only to make it enforceable. It make it easy to ask for the certificate using electronic means to do it and without a lot of costs. We would like not only reduce the costs of litigation, we also to design these proposals without burdens for citizens. Of course, always a burden to ask for something, but the minimum burdens possible. Using technology also to simplify our life and our relation with public authorities. Thank you.
Okay. Yeah, we have more than 400 people connected, watching. This is fantastic. If any of you among the 400, more than 400, would like to ask us a question, send one in, and we'll go. Here we go. Here's one. Okay. And of course, any of you out there too, here in the audience. Which legal steps would the Commission have to take if a member state decides to refuse the recognition of parenthood on the grounds of public policy while in breach of Article 21 on non-discrimination based on sexual orientation? Article 21 on non-discrimination based on sexual orientation. Who would like to talk about that?
Yeah, thank you for this question. Yes, we are asked this question also often. Well, as you all know here, the Commission is the guardian of the treaties, which means that the Commission monitors and is informed and receives complaints all the time about things that don't work for citizens. And it is on this basis that the Commission investigates and, if necessary, takes action, which means takes action vis-à-vis the member state that doesn't respect the legislation.
I think we will wrap this up soon, but there's something, that goes in my mind is that, Laura, you worked at UNICEF, obviously very much in touch with children. you know, a child who's in the middle of this, how stressful is that for a child? Without the clarity and the predictability that this could bring. Without that, what's it like?
Even at school to go in.
Even at school. Yeah, or making a medical decision, as Catherine said. Can we think about that? Can you talk about that?
Thank you. Well, it was a long time ago for UNICEF, but we do still work a lot with UNICEF. Just recently, Mongolia, for example. No, it is. We have to think about children. We have the best interest of the child, but it is interpreted in many different ways, and always not so many times really in the best interest of the child, but just taking how the interests are there of adults. So I really think we have to be very careful. We have to listen to them. I think it's important to be able to inform them, to explain them in a language that they can understand, and as well see what they think and try to resolve all these matters as quickly as possible. Because now we're speaking about children, but children grow up. And I do a lot of work on adoption, and we are very much in contact with adoptees, and they tell us how all this has affected them, all the discrimination, all the problems that they have on a day-to-day that may affect the way that they are being raised and they grow up and they are a person. So it's really something that we need to take into consideration, and we need to do something. It is said in our objectives when it is a child, because legal parentage doesn't stop at 18, it's for all persons at any age. Sure. But when it is, we have to take into consideration the best interest of the child as a paramount consideration.
Yeah, that the child does not become some sort of political football,
never, no,
right?
It should never.
Catherine.
Yeah, I mean, I've not worked for UNICEF, but I think I just want to add a few words. I think the political football you just mentioned is really important there, because that's what's happening, right? And then we have a lot of discussions on, does a child need a father and a mother? And is a child impacted by this? Is a child impacted by that? A child is actually impacted by discrimination. A child is impacted by hate it's facing on a day-to-day basis in society. A child is impacted if the family it's living for is being questioned and attacked by political leaders, by other parts of society. And I think we really need to keep that in mind. We referred to the Italian situation before, where the Italian government issued guidelines to local councils now to no longer register both parents of rainbow families, but also to deregister parents retrospectively. And that has led to cases where, for example, I've read in one article, a 6-year-old child had one of their parents deregistered and had to change its name because that's where the name came from. And that kid had to go into school the next day. I don't think that's a good situation, and that's definitely a situation that will impact the health, the well-being of that child.
Making a lightning round here, going out to you, to Alina. I mean, I failed to mention that you did write a report for the European Parliament on this, right? And any final comment with all of this in mind, and especially this focus on the child?
Well, it's very simple what I'm going to say, which is that families which do not conform to the nuclear family model, meaning non-traditional families as they are often called, have always existed, as has already been said. They are there. So it's more a question of ensuring that the law reflects the social reality. So by not voting in favor of this proposal, they're not going to stop anything. They are simply going to make the life of millions of children very difficult. So it's very simple. It's simply ensuring that the law follows what's going on in real life.
Absolutely. Absolutely, Alina. And Maria, from the Commission, a final quick word as we sum up, and then we go to Maria Manuel.
Thank you. Well, no, thank you again. For us, it is very useful and helpful to hear from people interested in this file, to to guide the legislation, the legislative negotiations, and we do hope that the current constructive atmosphere with the member states is kept for a long time. We are very grateful for the support of the Parliament, of the rapporteur, of her draft report, and yeah, we hope that this positive attitude towards this will transfer to the Council, and that we will manage to have member states on board also. Thank you very much.
Final comment, and my curiosity is, I mean, as a rapporteur, you are in contact with all of the other party groups in making this happen, right?
Yes, of course.
And so what is your sense? What is your feeling right now? What are the chances of its success?
It can change, but right now I feel that we can achieve a good agreement with a comfortable majority. Of course, we need to negotiate. We did some proposals now in the report, some changing a little bit what the initial proposal of the Commission. We are going to negotiate in other groups in order. It's my goal. It's my more important goal in order to have a big majority in the Parliament. I think it's very important to push the Council in the sense of the Commission, and I would like, it's not common, the Parliament thanks to the Commission, but I would like to thank the Commission for the proposal. It's a very good one, and also for fighting for the proposal in a constructive way with the Council. I know it's not easy, but we are together in the same sense, with the same goal, in the best interest of the child. I would like to repeat, this proposal is not about surrogacy, it's not about nationality, it's not to change family law in the member states, it's not about immigration. There are a lot of problems related to all these matters, but this proposal is focused only in protecting children's rights, in facilitate the recognition of parenthood in a simple way, and to reducing litigation, the costs of litigation, and the time to have a decision from the courts. It's very important because we are speaking about a child, and we cannot wait 2 years to have a decision. 2 years is a long time for a child. So it's what this proposal about. It could be only one child, but are expect 2 million or more cases, and it's why we are fighting for, and I hope this is the goal that will unite this Parliament at the end of the day. And of course, I want to finish Chris for this marvelous moderation, and it's provocative. It's very important to be provocative, and also Maria, Laura, Aline, and Catherine for their so relevant contributions. Also, S&D jury team, and special Andrea, where is she? No, Andrea and Leonor for their help in organizing the event, and of course, all of you with us and online who have attended and followed and questioned us online. Thank you very much.
Thank you. Thank you to everyone. Thank you to the speakers, to Maria for organizing this, and also to the interpreters. Please, a hand to the interpreters. Not an easy job. Thank you very much. And then you're not, for all of you, your job is not done. Think of the hashtag parenthood. Think of the handle at the progressives, and think about helping to move this thing forward. Thank you very much.